Chapter 29. Trial. The mode of trial has not been changed by the Code. Sec. 16447. Trial. The mode of trial has not been changed by the Code. Under this heading, what the Code Commissioners have to say upon the subject is quoted. Every issue of fact in an action for the recovery of money only, or specific real or personal property, will be tried by a jury, unless such a trial be waived. This is a very comprehensive provision. A moment's reflection will show that it will require that all cases heretofore triable by a jury shall be hereafter triable by a jury. But this is not all. While it comprehends every claim at law, it will, also, include many claims in equity, as they have been called. Every equitable claim for the recovery of money only, or specific real or personal property, will be tried by a jury. I doubt whether any such claim can be of an equitable nature. Whenever the action is for money only, or specific real or personal property, the case must go to a jury. The nature of the action, therefore, fixes the mode of trial. If an equitable defense be made to a legal claim, it will make no difference in the mode of trial. Our Constitution declares that the right of trial by jury shall be inviolate. The provision of the Code we are now considering, while it will impair this right in no respect, will secure it in many cases in which it has not heretofore been recognized and enjoyed. There is not the least doubt that the issues put upon the jury calendar will be greatly increased in number. Nor do we regret this. If the right of trial by jury in civil cases be so sacred and invaluable as to be worthy of constitutional sanction, it should be extended as far as it is here proposed. No reason is anywhere given, and no reason can be given, why a majority of the cases now brought in courts of equity are not just as much entitled to a jury trial as cases brought in courts of law. The only explanation of the difference is, one court has always had a jury, and the other has always been without one. It is a favorite idea that the trial by a jury is the best mode of trying disputed questions of fact. All issues of fact that are difficult and involve the veracity of witnesses and the weighing of doubtful testimony. Especially is this the case where the litigation has stirred the passions of the parties and is carried on under excitement. The court should be required to try no such issues, whether the case be legal or equitable, and, therefore, we find that by the practice of his court, the Chancellor has always been permitted to refer chancery issues to be tried by a jury. Indeed, according to the true spirit of chancery practice, it is expected of him, it is rather a duty to refer difficult issues to a jury. The mere existence of such an authority in that court from the beginning is an admission that a jury is the best forum for such trials. The above quotation discloses the design of the Code. Indeed, it was not within the power of the legislature to change the mode of trial, because of the constitutional guarantee of the same mode of trial as prevailed in the common law system.